Let's bring in Andrew Clennell now. And Andrew, a really interesting development you've got in this story. As I said, breaking news off the back of that High Court decision. What can you tell us?
Kieran, Sky News can reveal the Australian government were desperately attempting through its US embassy, while Anthony Albanese was on his state dinner visit to the US, to get the US State Department to agree to have the child sex criminal detainee NZYQ resettled in the US. This is according to documents filed with the High Court. The subsequent victory of NZYQ a month later in that court led to, as we know, the indefinite detention of immigration detainees being banned in Australia, and has since led to the release of 141 detainees now with serious criminal records. Well, departmental officials also said in this correspondence in early September that the Home Affairs Minister, Clare O'Neil, had taken an interest in the case as of the, quote, utmost importance, unquote, asking for all avenues to be explored to get this detainee out of the country. This is emails, as I say, released to the High Court. An email from David Gavin from Home Affairs, dated September 1 this year, goes to several officials and says in relation to NZYQ's case, quote, the Minister for Home Affairs views this case of the utmost importance and wishes all avenues, including difficult ones, progressed. No stone should be left unturned would be an apt summary. I think a further discussion is warranted on the approach to Bangladesh, making further inquiries and third country options to dispose of this detainee and end the High Court case. The frequency and nature of the email correspondence between Home Affairs Department officials appears to call into question the Minister's statements on Sunday Agenda a week and a half ago that her department had advised her the government was likely to win the case. Ms O'Neil gave this as a reason when asked why the government had been flat-footed on the case by me on November 19. You knew this could happen in June, though, didn't you, or did you?
We knew that there was a High Court action on foot. We knew that it was 20 years of legal precedent, and we were advised that it was likely that the Commonwealth would win the case, that is, allow us to do what we wanted to do, which is keep these people in detention. Minister, who advised you you were likely to win, and how recently did you receive that advice? Well, we received that advice from the Department of Home Affairs, who tell us what chances we have of success and failure in each legal case. But I do need you to understand that
when did you receive that advice?
I do need you to understand that our department is one of the most litigated against departments of the Commonwealth.
So during that interview, Ms O'Neil declined to say when that advice was received. She says that they were likely to win. But the emails tendered to the High Court show the Home Affairs Department was contacting the Australian Embassy in the US and asking them to lobby the State Department to resettle the detainee. The detainee won his case in November after this swathe of emails in September and October, and that has led to this precedent, finding indefinite detention of immigration detainees is illegal, and that's why we have 141 criminals on the streets. Well, some emails in September were even headlined, quote, urgent removal, unquote. The attempts appear to have been made partly to convince the High Court the detainee was not in indefinite detention, but also to get the detainee removed and resettled before a High Court decision could be handed down. So have a look at this email, dated Sunday, October 22nd, sent on a Sunday night at 10:30 p.m, with the PM having just arrived in the US. The Acting Assistant Secretary for the Department of Home Affairs, Noel Kerr, sends this email apparently to the Australian Embassy saying, hi, I hope the PM's visit is going well. Appreciate another update on whether the US has responded to you by close of business Monday your time. And another email from this official, Noel Kerr, dated September 27, 2023, talks about that assistance with urgent removal matter and says, quote, I'm seeking your assistance in reaching out to counterparts in the US, the UK, Canada, New Zealand to discuss the removal of a stateless Rohingya individual. Then there's this before the court, an affidavit from a Home Affairs official, Mary Bowsery, which says of the desperate bid to resettle the detainee, quote, I'm not aware of any other case in which International Division has approached the United States for third country removal of a specific individual and been advised that the US will consider the case. This makes the case unique in my experience on the basis of the US indicating they were prepared to take a hard look and the time they're taking to consider it. And she says it's impossible for her to say whether the detainee will be resettled. And there's one redacted document released by the Department of Home Affairs from senior official Marianne Agbinya from May 26, which talks about releasing the detainee. NZYQ versus Minister Indefinite Detention Al-Kateb Challenge is the headline. Proposal to reconsider exercising ministerial intervention powers under the Act in light of litigation risk. It's copied to the then head of the Department of Home Affairs, Michael Pizzullo, and a departmental liaison officer in the Minister's office. So Clare O'Neil tells us they were likely to win. That's why they were flat-footed. It looks like there were plenty of red flags in terms of this correspondence, and the Minister's name checked in there. Now, Minister Clare O'Neil has issued a statement to Sky News about these emails after we went to her office with them this afternoon. She says, in the comments I made on Sunday, and she means the Sunday Agenda program, I was referring to operational advice from my department which detailed efforts to remove the individual, in this case from Australia. This would have meant that this case may not have needed to proceed. So that's why she's saying they were expected to win. She goes on, I was not referring to legal advice. I don't discuss legal advice received by the Commonwealth. The Commonwealth and my department specifically have been preparing for the loss for some time. This is why work was undertaken before the High Court handed down its ruling. It does seem here, Kieran, clear evidence they knew for months. They were trying to take advantage of the state dinner, a visit of the PM to rely on the goodwill of the US to resettle this child sex criminal. Didn't happen, lost in the High Court. And then they seemed a bit flat-footed when that happened. It looked pretty obvious there were a lot of officials and the government itself fearing they would lose the case.
Leave no stone unturned, even looking at countries like Bangladesh as well as the United States. An interesting and timely story you've got this afternoon, because the High Court's just announced its reasons for that ruling will be released tomorrow afternoon at 2:15. So that would give, you think, the government, if it's of a mind to, legislate this week or next in terms of maybe a preventative detention order or something of that type before Christmas.
It's a quick turnaround. The Minister said in that interview she was expecting the reasons in February or March, after which the government would legislate. So we could see the House sit next week, you'd think, if they can get their ducks in order, or even subsequent to that, to get that further legislation in place.
They'd like to get it done, I imagine, before the place rises for the Christmas break.